Well, good morning. This is the Coronavirus Constitution, Episode 3. So, we've done the preamble, we've done Article 1, which dealt with Congress. Now we're going to do Article 2, which is the second branch that we've studied. The first branch was Congress. And Article 2 spells out the executive branch, which we refer to as the president and vice president. The election of the president and vice president is unlike really any other election that we hold in the United States, in that it is a indirect election rather than a direct election. There's been a lot of controversy over the way we do this in the past 30 years. I don't see it changing anytime soon. I used to think that it might when I was younger and more naive. But I don't know, potentially maybe in your lifetime you could see it change. But each state party gets to select a group of people called electors. And the number of electors a state gets is determined by their congressional representation. So the other day when we talked about Congress in Oklahoma, we talked about the fact that we have 5 representatives. So, and we have 2 senators. So that gives us a total of 7 electoral voters. If you look at a big state population wise like California, they have 53 members in Congress plus 2 senators, gives them 55 electoral votes. So the other flip side to this, that goes to one of the biggest problems that we have with it, is that you have the potential for somebody that can win the popular vote but lose in the electoral college. And it's happened a couple of times. Most recently in our last presidential election, and then before that in 2000. And one of the biggest reason why you can have that potential for a popular vote winner but a loser in the electoral college is that out of the 50 states, 48 of them use what's called a winner take all method. In other words, regardless of the outcome of the popular vote, the winner of the popular vote gets all of the electoral votes. In other words, in Oklahoma, we typically vote about 60% Republican to 40% Democrat. But the Republican candidate would get 100% of the electoral votes, which means they would get all 7, which doesn't seem like a huge deal when you're dealing with smaller states. But when you start talking about states like California and Texas and Florida and New York, now you're dealing with a lot of voters and sometimes fairly close outcome. So if you think that California's typically votes Democratic statewide, but it's a much more narrow popular outcome, usually in the 50th percentile, 55% to 45%. Regardless of that, the candidate that wins gets 100% of 55 electoral votes. And so you've got numbers all across the country that can result in if it's a close election, you could have an electoral winner that didn't win the popular vote, which, democratically, the people, have a problem with that. And again, I don't see it happening or changing in the near future. Presidential terms run for 4 years. They used to be unlimited terms. We now limit presidential terms to 2 full terms, and the maximum time they could serve is up to 10 years. And that's in case you have a vice president that succeeds a president and there's 2 years or less left in that term. That means that time doesn't count as a term. Now, if there's more than 2 years, then constitutionally it counts as a term. And we set the maximum of 2 terms in response really to FDR. FDR is the only president that served more than 2 terms. He was elected to 4, and he died in his 4th term during World War II. And so now we have this standard that caps the amount of time one individual can serve as president. The other amendment that deals with the president is the 25th Amendment. And there's a lot to this amendment. It deals with, it really kind of shored up vice presidential succession in the wake of the assassination of John F. Kennedy. But there are also aspects of it that deal with the incapacitation of the president. So if the president becomes ill, but he's not dead, but he can't fulfill the duties of the president, then there's ways using the 25th Amendment that power can be transferred. One of the reasons we do this is because the line of succession, number one, is very important to this country. We don't ever want to be without a chief executive. I always think about, when I think about this example, is the swearing in of Lyndon Johnson after the assassination of John F. Kennedy. They made sure that before Johnson left Texas, that he had been sworn in. So they brought a federal judge over and swore him in on Air Force One. Anyway, and you also have the Presidential Succession Act of 1947 that deals with basically the same thing. And we have a line of succession that goes basically through from the vice president to the speaker down through the cabinet heads, the heads of each cabinet. The remaining structure of the executive branch was to be determined by Congress and the president as needed. And what that basically means is what we talked about the other day, that it's a pretty flexible document, and it was meant to be able to deal with unforeseen circumstances, and that's why it was left that way. So the executive powers, we divide them up into domestic powers, which means these are powers that the president has within our country. And then foreign policy powers, these are the powers the president has in dealing with other countries. So domestic powers are, a lot of these, I think most of you'll realize, the president gives an annual State of the Union address, and the State of the Union means the condition of our country. And it's one of those things that it's kind of become a thing of pomp and circumstance and political rivalry. It's one of the things, believe it or not, that I don't usually watch. I usually read the State of the Union address that night or the next day. It's not that I don't want to hear it, but it takes a long time to get through that speech. There's a lot of grandstanding and standing ovations, and it just takes forever to get through it. And so normally I just read they usually release it right before the president gives the speech. So, but it is kind of a spectacle. Presidents also have legislative powers. They obviously sign bills into law. They also have the opportunity to veto a bill, which can be overridden by Congress, which takes a 2/3 majority, or they can take no action on a bill. So if Congress is in session, after a certain amount of time, the president refuses to sign a bill, it becomes law. But if it's towards the end of the session, and the president takes no action, that's what we call a pocket veto. In other words, he didn't take a direct action. He didn't veto the bill to give it back to them. He just lets it die at the end of the session. This doesn't happen as much as you would think, but it does happen. And then the administration of laws, that's where the term chief executive comes in. The president is the chief executive, which means that the execution of not just all the power, but particularly legislative power. And there's an obligation of the president to uphold and administer the laws that Congress sets forth. So then that's all federal law. Another huge power that presidents have is the nomination of executive officers. And the one that gets the most attention usually are federal judges, appeals court judges, and most importantly, Supreme Court justices. And we'll kind of come back to that in a minute when we talk about the judicial branch. Foreign policy powers, presidents can sign treaties into law. This takes a 2/3 majority of the Senate approval, which is typically very difficult to get. And there are ways around this. Something called executive agreements, and Supreme Court's upheld executive agreements. It does not require Senate approval, but the Supreme Court basically said they were constitutional because Congress controls the financial obligations, and typically treaties deal with something along those lines. Congress does have enough of a check on them to be something that's considered constitutional. Presidents can also recognize other countries, giving them some legitimacy. And then, and I think most kids realize this, the president is the commander-in-chief of all armed forces. And so that's that's one of those things that we typically don't think about until there's something catastrophic going on, but that's a tremendous power that the president has as the commander-in-chief of all armed forces. And the idea in the Constitution was to keep a check on our military by providing a civilian at the top of the military. So we move now into Article 3, which is the Judicial Branch. So this is our court system. And this is one that sometimes kids have a hard time wrapping their head around this, but mostly what we're going to talk about as far as here with the Constitution, we're talking about our national courts. You and I, though, if we ever have any dealings with a court, it's more than likely going to be a state court or a city court. But what we're talking about, and it's very similar in its structure, is our federal court system. So at the very top, we have the Supreme Court, also known as the Court of Last Resort. You cannot appeal beyond the Supreme Court. Their decisions or their ability to make no decision on a case is final. We have 9 justices, 1 Chief Justice with 8 Associate Justices. And just like all other federal judges, with the exception of just a few, they serve life terms. The inferior or lower federal courts were to be established by Congress, and the base structure that was set in 1789 we still use today. And again, these are for the most part what we consider to be our district federal court judges. They are nominated or appointed by the president, and they are confirmed by the Senate. And so that's one of those things that is a check on presidential power because of the confirmation process by the Senate. And again, these judges serve a lifetime term until they either choose to retire or they die. And the only other way they can be removed is through impeachment and conviction, which has happened. It's still very unusual, but it still has happened. But I just talked about that. They serve a life or they have permanent tenure. One of the reasons they do that is, and this is also something that's kind of a hot topic right now, is whether or not this is something that serves our country in terms of our best interest. That they do have lifetime or extended periods of time. They don't have to answer to voters. The reasoning behind this is that you want them insulated from public opinion. Public opinion sways and ebbs and flows, and we want our judges to hold themselves to a true constitutional standard. In other words, that's the ultimate litmus test for our federal judges, including the Supreme Court. And that, for a lot of people, that kind of seems like a bit of a stretch. I'm really of the opinion that I don't have a huge problem with these lifetime appointments. I think that if we were to see any change, it might be within the ranks of the Supreme Court, but it would be very difficult to get that changed through a constitutional amendment. So just like I said earlier, we have a dual court system. And most states, including the state of Oklahoma, created their court system to be almost a mirror like reflection of the federal structure of our court system. In both cases, courts are reactive. And what that means is they can't seek out cases to be brought to them. The cases but must be taken to them through some kind of action, either criminal or civil. And obviously the appeals courts operate a little bit differently, and the Supreme Court operates a little bit differently. But in most cases, where the workhorses of our judicial system are our district courts. And I would say in Oklahoma it's the same thing. Our state district courts, but our federal district courts, they handle the bulk of all criminal and civil cases all over the country. And in the vast majority of those cases, that's where they end. So what's the difference between criminal and civil? In criminal, somebody's broken either a federal law or a state law, and the prosecution is done by the state or by the federal government in both cases. So if it's in the state court, it's going to be a state prosecutor that brings charges against a defendant to take them to court to be determined whether there's guilt or innocence. In a civil matter, you're dealing with private parties. It could be two individuals. It could be a business and an individual. There's a variety of things. But the most common in our state in terms of civil matters would be divorce. This is where a married couple, for one reason or another, decide to end their marriage. And if they can't have it mediated, then it is usually done in a civil court before a judge. The last thing that I want to talk about before we get out of this is that we do have an appeals court system, and that is how the vast majority of cases are going to make their way to the Supreme Court. And it's a very slim number in terms of the number of cases that are currently in our court system. But we expect the Supreme Court to be the court that helps guide the country with regard to could be big time racial issues, it could be social issues, and they are the ones that are tasked with sometimes resolving really controversial issues. And again, it kind of goes back to the reason why they have lifetime appointments. They don't want to be, if these were elected officials, we don't want them pandering to one political side or the other. This gives them that insulation that I was talking about from public opinion. We want them to rule as the best they can according to Constitution and constitutional principles. And so that's why they do have a lifetime appointment. There are issues with it, but I do think it protects our judicial branch from becoming political or partisan. And the last thing that is spelled out in Article 3 is treason. Treason is the only crime that's defined in the United States Constitution. In other words, all other crimes have been defined by Congress. But treason is considered levying war or an act of war against our government or aiding the enemies of our country, of the United States of America. Treason can only be committed by a U.S. citizen or a resident during times of war. The punishment for conviction. The minimum is 5 years in prison and a $10,000 fine, and the maximum is the death penalty. And that's the only crime that we define for the death penalty outside of capital murder in this country. All other crimes are either levied by jail time or through some sort of fine. Okay, that's where we'll stop for today, and we will see you next week.